My name is Katie Naples Mitchell. I guess I really should have started with that. And I'm the program director here at the Program in Criminal Justice Policy Management. And we are really delighted to have three wonderful guests, Michelle Lewin, Anthony Dixon, and Lisa Berlin joining us today. And I will give fuller bios of the three of them. But before we do that, I just wanted to jump into a little bit of housekeeping. The link that you have joined today is the link for all of our events for the whole semester, and we are running two kind of simultaneous programs this semester. So we have our speaker series on the myths of public safety around parole, which today's event is one of, and then we also are doing special topics with members of the Kennedy School community and beyond who are doing related work on a range of issues around policing and substance use and intersections with public health and police training and public housing and again, a whole range of things. So those topics are also peppered throughout the semester. Next week's talk by David Scholter is exactly one example of that. And then we will be returning April 26th to another parole related topic. All right. I guess I will now pivot to some introductions for our guests today. So we have really more than two organizations represented here on the panel. They all are involved in many different projects, but in particular, we want to talk about Parole Preparation Project in New York and Parole Watch in Massachusetts here. And there's also a burgeoning project in Massachusetts that's kind of modeled off of parole preparation in New York that Lisa may also tell us a little bit about. Their full bios are on our website. And again, that link is here. And I will try to drop links in the chat throughout that are relevant to what we're talking about. But I will give little summaries. So Michelle is an attorney in New York State, graduated from CUNY School of Law. She previously worked for the Fortune Society and has done a lot of work around and against incarceration for the last almost 20 years. She founded the Parole Preparation Project of the National Lawyers Guild as a first-year law student, and now is the executive director of the project and has written lots of articles and done a lot of legislative organizing, as well as managed dozens of volunteers. So we're really glad to have Michelle with us today. Joining us also is Anthony Dixon, who has helped secure the release of many people serving long sentences in New York State, has helped many people prepare for their transitions home, and is an organizer and activist working on policy reform and building strategic partnerships, and did a lot of that work behind the wall himself. Anthony, we're so glad to have you here with us. And then finally, but last but not least, Lisa Berlin, who is a volunteer with Massachusetts Parole Watch since it was formed in summer of 2020, which is a civic volunteer group whose members attend public hearings at the Parole Board for life sentence prisoners, collect data, and document observations about the Parole Board's process. And she is also on the steering committee of the burgeoning Massachusetts Parole Preparation Initiative. I hope I got that name right, Lisa. And we're really delighted to have all three of you here with us today. So without further ado, I'm going to jump in just by asking you all to give us some background about the work you do and how you got into it. And we can start with Michelle and Anthony. Before we dive in, I just want to mention that, our last event in this series was featured Vinnie Schiraldi, who talked to us about kind of big picture scope of thinking about the role of mass supervision in communities and the way that the system of mass incarceration is, paralleled, if not exceeded, by the system of mass supervision and mass criminalization. And so I think today's event is an opportunity for us to think about those pathways back to incarceration that parole and probation, but parole in particular, often serves as, and identifying these systemic problems around due process and access to release that in the context of individual people's stories, as well as building community power to fight back against those systems. So again, starting with Michelle and Anthony, tell us about parole preparation. How did you guys get involved? What's the story?
Sure. Anthony, you want me to start or you want to go ahead?
Yes, please do.
Okay. All right, I will. Hi, everybody. Thank you so much for having us. It's really just such a pleasure to be here and to see so many of you on this call. It's a really exciting conversation to talk about parole, and I think also a very devastating one all at once. So I started at CUNY Law School in 2013. Before law school, I had already been doing some work with incarcerated people, mostly young people, and sort of the alternatives to incarceration setting. But basically, when I began in law school, I was very, very lucky to be involved in the National Lawyers Guild, which many of you probably know is a sort of wonderful leftist bar association that has a long history of social justice work in this country. And basically, the National Lawyers Guild had a committee of attorneys that had been working on incarceration issues for many years. And they had gotten a letter from people at Otisville Correctional Facility, which is a prison not too far outside of New York City, from a lifers group there. And basically, this group is composed all of people serving life sentences in New York State. So what life means, just quickly, in New York is basically an indeterminate sentence of something like 25 years to life, 15 years to life, something like that. And anyone serving life, their only way out in New York State is through the Parole Board. So a group of lifers at the time at Otisville Correctional Facility basically reached out to lawyers in the community and said, we are getting hit over and over and over again at the Parole Board. It doesn't matter what we present to them. It doesn't matter how much we prepare for parole interviews. We are getting denied, and we are aging very rapidly behind bars. You know, many of the people in this group were in their 60s, 70s, 80s, had been in for 25, 35, 40 years. And basically from that correspondence and from that communication, we were invited up to Otisville, to the prison itself, to have a long one-day summit to talk about parole, to really dig into the issues, to learn about what people in prison were facing. And sort of out of that conversation and out of that kind of ongoing relationship and dialogue came this very small, initially scrappy initiative back in 2014, where basically me and a couple other law students and lawyers were working with people in prison to support them as they're preparing to go for parole. So working with people to, get ready for the parole interview itself, practice interviewing questions, get used to the video conference technology that many people are, not exposed to in any capacity in prison and suddenly seeing for the first time in this setting. And then also putting together the written materials that people in prison often submit to the parole board on sort of their own behalf. And those written materials often are called a parole packet. Some of you might be familiar with that. And so, in the first year or two of the project, it was just me and a couple other advocates and lawyers sort of fighting for a few individual people to get out. And the first person we worked with had been in for 36 years, had a final order of deportation, and was denied parole twice within the first 2 years of us working with him. And basically, his parole denial sort of, I think, galvanized all of us and really started to expose some of the just horrific injustices that were happening inside prisons for people who were serving life sentences. And sort of to make a long story short, over the last 10 years, I, along with many of my colleagues, have been able to train somewhere close to 700 volunteers and work with about 400 incarcerated people serving life sentences, basically in preparation for parole. So our volunteers work in teams of 2 or 3 and partner with one person in prison for however long it takes, essentially, to get them out. And, the work that we are doing, yes, is about securing release for people who are serving long sentences, but it's also about building relationships. It's about building relationships between people on the outside and people on the inside, building relationships where I think there often are no ties, right? Many, many people who are incarcerated have family on the outside, have loved ones, but many people do not. They've been in prison for so long that some of their family may have passed away, they may have lost touch. And some people, I think, are really eager and sort of longing for community ties. So through Parole Prep, we're building a strong network, a vibrant network of formerly incarcerated people and volunteers and advocates. And in the first year or two of that work, I was very, very fortunate and lucky to meet Anthony Dixon, who is my mentor and my favorite colleague of all time and just my most favorite person. So I'll turn it over to him, but I'm happy, obviously, to talk more about parole and everything else.
Thank you, Michelle, for that compliment. So by way of background, I was in prison for 32 years. And during those 32 years, I was in lifers groups and also chaired 2 lifers groups in different facilities. I've also litigated against New York State prisons and won one of the class action lawsuits that still have ripple effects dealing with discrimination against people of colors and giving preferential treatments to non-people of colors in 4 different areas of a DOC system and how they operate. But without going into the weeds on that, I learned while I was inside that New York State has the 2nd largest prison budget in the country, as the 2nd largest law enforcement in the country, and also has the 2nd largest percentage of lifers in the country. And that was alarming, in addition to finding out other 1st place and 2nd places that New York State, or so-called progressive state, is in. That is really the Empire State in so many wrong ways. And so that was concerning to me, because being a person that's impacted, I wanted to learn more about the system that was oppressing me. And when I got out, I left behind some very good people that I felt that I had to help come home. And in my pathway of doing that, many of these individuals only had parole, the hope at parole. And there was one time like a 90% denial rate in New York State prison system. And many of us was horrified to go to the parole board. And I mean that literally horrified. It was not a space that you felt comfortable in. It was not a humanizing space. It was a space that, rather than feel that your day of release was approaching you, it was another system that punished you. And for some of the people that I was with, one individual really stands out to mind is John McKenzie, who committed suicide 2 weeks after he was denied. He went the same time I did, and he was my mentor. And he should have been released. He should have walked out the gates with me. And so I vowed when I left prison that I would not forget where I came from. And I felt that I had to represent my community out here, as does many lifers that leave out of New York State prison system, specifically when it concerned the parole board not really giving us a fair shot. And during that time, Michelle and I had met up. I did work with Parole Prep for 2 years as a co-advisor. I was in Monday meetings, though I was working another job. I made it my business to volunteer and get in the weeds with these subjects, because I felt that people from my community voice needed to be heard. And I felt that in the 2 years I was with her, she understood that perfectly well, more than other people that I was intersecting with. Not to say they didn't, but I really felt that she had a heart for the community of people that was treated so unjustly. And eventually I laid out a job description, and she invited me to come on. I tugged a little bit, and her, Nora, and Andrea Stewart Bible, who is now deceased, talked to me into coming aboard. And I really felt that this was part of my life mission. And part of that, as was mentioned earlier, was advocacy, organizing, and also helping people once they come home make a smoother landing. Because it's not enough to just get people home. We have to make a pathway for them to become gainfully employed, provide some type of resources for residents and medical coverage, et cetera, et cetera. And I'm going to end on this note that for the time that parole board ever existed in New York State, there has never been a follow-up process on preparing us for the parole board. When we go to court, we assign an attorney. And if we go to trial or the jury, we're there to be, our attorney is there to prepare us. At the end of our punitive stage of retention and being in prison for so long, we don't have nobody to represent us. And we don't have nobody to prepare us. And we're now in our 50s, 60s, some 70 years old or older. It is a perfect environment for people like us to feel that we're going up an uphill mountain. It's a void of not just not being prepared, but we have an environment where we meet perfect strangers who we must devour our most intimate failures to within a matter of minutes. And if we're unable to do that, and even some cases when we are able to do it, articulate ourselves and tell our narrative in a nutshell, we are still denied, but more so when we're not able because they look at that and they punch holes in it. And then after that, the administrative process. So there's a front door and a back door of this process that we call due process at the end that we looked at that is broken. And the two bills that we champion, we look at as a back door fix to a front door problem. So I end with that. Thank you.
Thank you for that. And we're definitely going to come back around to hear more about exactly what you mean by that and what those legislative policies look like. And thank you for being so candid and talking about really difficult subjects and people you both have lost. I think, we're holding space for all those folks today too. Lisa, the project that you work on is slightly different, right? Well, you work on a project similar to this also now, but the project that first got you involved in parole is looking more at a structural level at the parole board's process from a kind of different vantage, right? Instead of looking at it through individual cases and how to prepare people to come home and to be able to stay home and be safe and be gainfully employed and have medical care and have housing, all the things that Anthony pointed out are critical to this. You're looking at data transparency issues and rates of release and these kind of more structural questions. How did Parole Watch get started and what's the nature of the work that you're doing?
So Parole Watch was started by, Jean Traunstein, who was an advocate who was also a journalist and has written quite extensively on criminal justice and also did Shakespeare at Framingham Women's Prison for 10 years. We are a group of volunteers. There are currently about 15 of us, which is small, but I like to think very scrappy and has accomplished a lot. We include several attorneys, and we also have some mental health advocates as well. We are committed to attending lifer hearings, which are in person. So volunteers go to hearings at least once a month, and then we take notes on them, and then we have a whole form that we submit, and we accumulate a significant amount of data, which we've been using for various things. And then we have a monthly meeting, which is a part support group, because it is really intensive work. And as Anthony has alluded to, these hearings are incredibly high stakes affairs and can be very emotional and very, very draining for everybody involved. So we have a monthly meeting, which is a support group, and then where we strategize about what kind of things we can do to affect change. So the Parole Watch was designed essentially to keep the parole board accountable. Hearings for lifers are public in Massachusetts, but they are not, they're not streamed. So they are in person, you need to go in person. The nature of these hearings can be very disturbing when one first goes, because there's often a lot of detail around the original offense, which could have been committed, obviously decades ago. And also because of a lot of the insensitivity around the questioning, which can also be very cruel. Now, I just want to say at the outset here that we started this 3 years ago, and the board today is, I want to say, significantly different. And I will point that out as later as we talk. But so some of the things that I'm saying about the board are not necessarily the current situation right now, but this was definitely the situation that we walked into at the time. And there's so many aspects of the parole process that are incredibly opaque. And our goal was basically to shine a light on that process. And through more of the questionings, I'll get into more of the details about how we've done that.
Thanks for that. Yeah. And I think, obviously these are different vantage points looking at basically the same problems, right? It's in terms of, Anthony hammering home due process, right? The lack of availability of counsel to prepare people. And so you all have built a 700 person strong volunteer network to stand in the breach to help people figure out what their home plans and release plans look like and practice answering those really deeply personal questions, many of which may or may not go towards factors that are the parole board's charge in thinking about whether somebody is ready to leave prison in their statutory role, right? And the same is true for kind of the work that Parole Watch is doing, but as kind of accountability outside viewers, right? Instead of being deeply invested in making sure that people are prepared, watching the parole board members in their questioning and watching how the board operates to what extent their decisions include detailed applications of the specific factors they're supposed to consider for people versus boilerplate language that they recycle in decision after decision after decision, right? Which makes it really hard for people to know what to do to improve if they're going back before the board for their 9th or 10th time, I think, as Anthony alluded to. So I want to get deeper into some of those questions. I know you all probably have a critique of parole as it exists, as it's structured. And I wonder if we could kind of dive deeper into that. What are some of the core due process concerns inherent in the parole process as it's currently structured?
Sure, I can kick it off and then I'll hand it to Anthony. Maybe we'll just stick with the same order. I think, yes, certainly there are due process issues in parole, but I think more profoundly, there are just horrifically immoral issues in parole and questions of just like deep, I don't know. I think questions about how as humanity we want to grapple with harm and how as humanity we want to grapple with violence in our communities. And yes, I think it raises questions about the law, but I think even more importantly, it raises questions about, mercy, redemption, transformation, punishment and confinement, and what are the purposes of those things, and are they effective at doing what they think that they're doing? And so I always push us to go beyond just questions of like, is it fair, but is it moral? Is it ethical? Is it just? And I think in my mind, the answer to all those questions is no. I think the pieces that I'll just focus in on, and there are many, many pieces to talk about with parole, but it's something we've already touched on, which is that, the parole board in New York State, and I think across the country, parole boards everywhere, are focused almost primarily and exclusively on the nature of people's offenses. They are, interested in both like going back 30 years and talking about the gory details of what happened, doing, deep investigation into the facts as if they were a trial court, attempting to sort of get a confession out of someone or get enough facts to convict them. The parole board, I think sees itself oftentimes as a law enforcement agency, as a prosecution, as an arm of the prosecution. And in my mind, that's not at all what parole boards should be. Parole boards, in my dream world, there are no parole boards and there are not people in prison who are forced to go before this body. But if we have to live with the system with parole, the parole board that I'm interested in is one who cares deeply about who a person is today. What accomplishments have they done in prison? What is their own narrative about their lives and who they are today and what they've sort of come to in terms of their own self-reflection and their own own personal work and growth, and certainly not forcing all or certainly not having every parole decision rely on does this person have 5 master's degrees and have they done all these things in prison, but is this person ready to come home and be in community? And I would say that for 99.999 if not 100% of people who have served long sentences, the answer is yes. People who have been in prison for many decades pose absolutely no risk to public safety. All of the statistics show that. Everything, every research that's ever been done about reincarceration rates for older people, for people doing long sentences, for people convicted of murder show, that people who have done that kind of time and spent that kind of spent that amount of time doing the self-reflection work are not returning to prison. And the truth is that I don't even know if I care so much about the recidivism rates, right? Like I'm still kind of stuck on this moral question of like, what does it mean to keep a person locked up in a cage for 40 years? I mean, we have, many people that we work with who spent 30 of those years in solitary confinement, right? Having absolutely no contact with other individuals, being completely isolated and never even touching the hand of another human being for 3 decades. So, when I'm thinking about parole, I'm thinking about, is this the world that I want to live in? And is this the world that I want to see, where we lock people up for eternity and sort of throw away the key? And for me, again, the answer is absolutely not. We at Parole Prep, I think, really take the position that no person should ever be defined by the worst thing that they've ever done, and that no matter what harm a person has caused, doesn't matter the severity, the horrific nature of it, every single individual deserves a chance to come home, to be reunited with their family, to be reunited with their community, and to be a part of the free world again. And I think that's one very important piece to me. And then the second piece that I just want to touch on, again, there's so much to touch on, but I think in New York State, and I imagine this is true in other states, is that the role of special interest groups, for example, like law enforcement or, other quote unquote victim or survivor groups in the parole process, I think is something that needs a lot more attention and a lot more exposure. In New York State, for example, a person who's in prison for harming a police officer, no matter how long ago it was, no matter if the officer suffered injuries or did not, the Police Benevolent Association, which is the union that represents police officers in New York, comes out every time, opposing people's parole by submitting thousands of letters telling the parole board about how horrific this person's crime was, about how, unbelievable it would be if the parole board would consider releasing this person. And if and when parole boards do release people who have been, entangled in violence against police, the Police Benevolent Association harass that individual. They threaten to rearrest that individual. They basically, I think, believe somehow that their interests are superior to all other human interests, and that harm against a police officer, a member of law enforcement, is somehow a crime that should be treated like no other, and that it sort of lives in this special land of no rules, no restrictions, no boundaries, and that basically anyone who does anything against the state in that way should be locked up indefinitely. And I find that so disturbing and so also so antithetical, I think, to what the parole board purports itself to be, which is sort of this like independent administrative agency that's supposed to be sort of reviewing cases and people's eligibility for release, and actually is really none of that. And sort of connected to that issue around law enforcement and special interest groups, I think, is this broader question of like, why are parole boards so political, right? And what does it mean to have parole boards, at least in New York State, where the commissioners are appointed by the governor and confirmed by the Senate, and that there is no members of the community, no formally incarcerated people, no family members of directly impacted people making decisions about who is on that parole board. And as you can imagine, right, the governor's, sort of political perspective and sort of slant towards crime is going to heavily influence how the parole board makes their decisions. So in New York, a parole board commissioner who is seen as more progressive or more liberal than the governor's kind of stated position on crime is likely going to be fired by the end of their term, or even before, or pushed out from the parole board because they're releasing too many people in the eyes of the governor's office. So the position is not protected by any means, and I think is very susceptible to a lot of political influence, a lot of special interest influence. And I think that's, just a very serious issue. But again, so much more to talk about, but I'll turn it over to Anthony.
Right. So I think what Michelle is saying is consistent with what was the original purpose of the parole board. And it's not like that today. And that's what I think she's pointing on out. The initial purpose of the parole board was created in New York State, ironically, as a body that would de-incarcerate an overpopulated prison, right, system. And it was given the task to evaluate a person risk, public safety. That was it. It is not a body that is supposed to re-sentence. It is a body that's supposed to evaluate at the minimum term of an indeterminate sentence that the judge said this is the time that the person should be evaluated to see whether this person is still. And the fact that that indeterminate sentence is there implies that a person can change in that indeterminate sentence. And not that the person forever stays that. If that is the case, there's no need for an indeterminate sentence. And for a person to be given an indeterminate sentence, regardless what crime they may have committed, whether it be law enforcement or petty larceny or whatever, it means that the person can change. It also means that it's wrong for law enforcement to try to bully parole board commissioners into violating the spirit of the law, to go against his mission, to push aside. This is law enforcement who's supposed to enforce the law, telling them to ignore the purpose of parole, to evaluate and continue to punish. The other thing I wanted to point out is some of the items that we look at that is very important to the parole board process that is not in place. And that has to do with disclosure, the composition of the parole board, the rationale that Michelle had pointed out behind parole denial, corrective actions that are now in gear, and also the appeal process. So those are areas that we look at due process issues throughout at the front with disclosure, how the parole board has unrestricted access to parole applicants' records, and yet they do not share it with the individual, and they go before the parole board with crimes that may not even be on the preview that they know about and that need corrections. I myself had a case like that. I was charged with 2 uncharged crimes that later on belonged to somebody else, but somehow they got mixed up. And I was telling my counselor, who told me, you're not supposed to know about this. I said, but I'm in enough trouble of stuff I did. I don't need to have stuff on my record I don't know. And I don't need them to second guess that at the parole board that I did that. That'd make me like a serial guy, you know? So that's like disclosure issue. Michelle had focused on the composition of the parole board, somewhat how we are used to upstate district commissioners from the red part of the state being assigned primarily from law enforcement. Over the years, we've been trying to change the composition of the parole board, but that has everything to do with personal interest, because they come from districts where these prisons are at, where entire communities are sustained by these prisons, and people that got life sentence are the cash cow, because you can continue to hold them in to keep these prisons open. So they have invested interest. They should be recused if they're in law enforcement, because they feel that they're part of the Blue Shield and they cannot hit individuals for, release individuals for certain crimes by virtue of the club that they belong in. When we deal with the rationale behind the parole board denial, Michelle had pointed out how it's always the nature of the crime, or the crime of conviction. And the Vera Institute did a study around 2 years ago that said 90% of the individuals that are denied parole in New York State is done on the basis of their crime of conviction. And that means that the person should never have a shot at parole if that's why you're going to hit it. And they have perfect autonomy to keep hitting you that way. That's due process in New York State. And the corrective action that is used once a person is denied is the parole applicant is held for 2 years traditionally. And in many instances, the parole board does not deny the action that should be taken by the individual in the interim of those 2 years. So they can be hit potentially over and over again for the same reason. And in many cases, when you hit people for the nature of the crime, if not all of the cases, there's nothing that they can do. And then there's the appeal process that she alluded to, that they feel that they must insulate their job. I don't know if everybody's aware of this that's on this Zoom today, but they make up, a parole board commissioner make up with $170,000 annually. I pause for a minute, just let that soak in. And you got 6 years to stay there. How much does that turn out to? And if you let the wrong people go, you may be chopped rather than renewed for another 6 years. You may just be chopped off of that count of the parole board commissioners. And so this is a very politicalized space. That means that the parole board cannot, as is, function according to its purpose. It is not based on safety inside of our communities. And by the way, most of the individuals that come from these upstate areas, they will never be released to the communities of these parole board commissioners. And so we believe, like a similar law inside New York, I think it's called the Batcher case, where jury of your peers is used. We believe that a composition of our peers should be used on the parole board, and people that come from different professions and not typically, as now, law enforcement. Thank you.
Thank you. Thank you for that. And I think, part of what you all just teed up for us, and Lisa, I'm sorry to interject. I know you're ready to jump into, but is, and harkening back to our theme of this semester, the myths of public safety, right? The parole board, I think, stands on that myth that it is producing safety and keeping people who are dangerous out of community. And I think the point you just made, Anthony, about all of the political dynamics that are guiding those decisions and all of the pecuniary dynamics, all of the financial interests, not necessarily just personal, but in terms of resources for upstate communities where people from downstate are ripped out of their home communities that might deeply welcome them back. And then those relationships, like you said, Michelle, sever over time when people are serving long-term and life sentences. And then it makes it so much harder to re-engage at the moment of potential release through parole, right? That those are structural inputs in terms of where prisons are located, which become jobs programs in communities, right? All of those kinds of inputs are big pieces that are behind the scenes guiding some of the decision making that happens both in the way that the parole board chooses to produce data and talk about its work, and also decision making in individual cases. Lisa, you want to respond to those ideas?
Reiterate to what Michelle said about, obviously the emphasis on punishment rather than rehabilitation and on the original crime, obviously. But also in terms of the public safety risks, what we have documented a lot is what we would call the lack of consistency in decisions, which is that some of the decision making is capricious and arbitrary in the sense that the records of decision don't necessarily give directions for the next hearing. And so the parole applicant is left without clear direction about what they're supposed to do for the next hearing. And then there's no follow through at the next hearing about whether they did complete what they were supposed to before. So there's just, I would say, no clear standards about what is being looked for and no clear direction around programming. And then also with setbacks, typically, is a 5-year setback. I mean, anywhere between a 1 and a 5-year setback, but there'd be setbacks for, decades where you just go 5 years, 5 years, 5 years. And it's not clear what these setbacks, the conditions for the setbacks are based on. And so that also seems very arbitrary and is really problematic. And also, when you touched on the nature of the crimes, it's something we've started to document too, that certain crimes, obviously, killing a policeman or something like that, but also sex crimes, domestic crimes, crimes against children. These are all crimes that for some, definitely have a much lower parole rate and really need to be looked at. Anything else that they wanted to add here? And that also just in terms of public risk, I mean, lots of times it seems that people are kept inside because there's no place to put them. I mean, that we see that a lot. These are aging people who have lots of illnesses or disabilities, mental health issues, and they might not have any family or community support. And the parole board essentially doesn't know what to do with them. And so we've seen this become more of a problem.
In terms of, thinking about setbacks, I know some states call them future eligibility terms, but I just want to be clear because I know I've been in a parole hearing where I've heard victims' families reject that term, in part because I think that people can feel like it's diminutive, and it's not meant to be like, this is a setback you have to overcome. The term is a legal term suggesting that you are not able to go back to see the parole board for a set period of time. So I just wanted to clarify that, because I've heard confusion about that in the real world. And I think it's one of the big questions for sure about it certainly relates to judicial review and appeals of decisions, and also, you know, the next time that if you don't have access to judicial review, the next time you get to see the board is set by the board itself, and maybe absolutely as much as 5 years, if not more than that. There are some states where the default, you know, future eligibility term or setback is something like 27 months, but people can be given 15-year terms before they're eligible to see the board again, depending on the state. And I know we're getting comments also that, you know, the financial structure of parole may be very different in other places. They may not be salaried positions. People may get per diems. And I think that certainly is an important point to bring out. And it changes the incentive structure, absolutely, in terms of how parole board members operate, but it I think doesn't necessarily cure the concerns about due process and cursory review and boilerplate language, right, that we're thinking about here, and might in fact enhance them potentially, depending on the nature of the structure. Again, a reminder to our audience that if you have questions percolating, feel free to put them in the chat now, and we can pause for more questions anytime. I think we've already touched on the kind of next question that I had prepared about, you know, the parole board is supposed to be focused on rehabilitation and looking at the person as they are now, right? That's, I think, what you brought out, Michelle, is if we're going to have a system of parole, at the very least, that's what its focus should be on. And there are some states that do have that structure written into the law. Some states, by contrast, do not focus on that and allow intense focus on the crime of conviction. And even when the law says do the former, sometimes the practice says that what's really happening, like in New York State, is a focus on the latter. I think getting back into the notion of how that relates to community safety, right? The parole boards increasingly use risk assessment scoring tools, right, which we know have baked in bias based on studies that suggest they assess factors that have, you know, tremendous socioeconomic and racial disparity. But beyond that, then are asking questions and probing intensely into somebody's life. And how much do you think that people being denied parole is really about community safety in your experiences working with individual cases versus about people not understanding how to present themselves before parole, people not having access to resources, the point that Lisa just made, right? These other kinds of structural factors.
Sure, yeah. I mean, I think one important thing, or just one interesting thing about parole in New York State, is that the standard that is in the law, is in the executive law that sort of governs and you know, tells the parole board how they're supposed to make decisions, starts by saying parole should not be a reward for good conduct, which I think is just such a wild introduction to a statute that is supposed to be, you know, about guiding these parole commissioners as part of this sort of independent agency in their determination of whether someone is, you know, community ready. That it starts off with this like incredibly punitive, incredibly adversarial notion that like the parole board isn't there to sort of pat you on the back and say good job, but they're there to punish you essentially. And you know, a denial of parole means that can mean many things. And so I think, you know, in New York State, basically, and somebody I think mentioned this in the chat about the stated purpose of parole based on the statute. You know, in the statute, it goes on to say that parole shouldn't be a reward for good conduct, and that, you know, a grant of parole cannot deprecate the seriousness of the crime or undermine respect for the law. So again, the standard is completely written in this framework, not of, you know, does this person pose a risk to community safety, but does letting them out basically offend our sensibilities of what the law is supposed to be doing and what the law was designed to do, which, you know, I think is just unbelievable. And as a person who's often litigating denials of parole, right? So Anthony sort of touched a little bit on the appeals process in New York State. And I think it's a really important part or aspect of the parole process that's deeply flawed and sort of responsible for re-entrenching a lot of the problems with parole to begin with. You know, when we are challenging denials of parole, this statute is incredibly slippery and difficult to actually litigate around because it's not exactly clear even what the parole board commissioners are supposed to be looking at, what they're not allowed to look at. And basically, you know, the statute, I think, and from my perspective, gives commissioners essentially, you know, latitude to deny on any basis alone. So I think there's a lot of structural issues. And, you know, one piece of advocacy that we are working super hard on, and maybe we're going to get to this, but I'll just jump the gun a little bit, is, you know, we have been for the last 5 years pushing really hard for a new piece of legislation called fair and timely parole, which basically kind of flips the statute on its head and says instead that parole should be granted, that there should be a presumption of release for any person who has reached their minimum sentence. And the parole board can only deny parole if they can show a good reason for that denial that relates to who that person is today and what, you know, possible risks they may pose to community safety that cannot be mitigated by parole supervision, right? So I think, like, just thinking about that reversal of the standard really, I think, opens up a big door for conversation about, like, okay, right, what is the purpose of parole? Is it to just continually incarcerate people until they themselves can prove that they're ready to be released, up against a standard that's unclear, up against a law that makes no sense, up against factors that are mostly, you know, focused on the nature of a person's crime? Or is it that everyone gets out who has served the minimum sentence because that is what the courts ultimately intended, and that the maximum of the person's sentence, oftentimes, which is life and is indefinite, you know, was there to be a safety net for someone who the parole board may determine, you know, really does pose a risk to public safety. I would argue that risk, quote unquote, to public safety is actually also a very problematic term. And, you know, I think that ideas about risk are very much rooted in white supremacy and race, and especially ideas about crime and what is criminal. And, you know, I know that's for a different panel, maybe a different day, but
also for this panel, totally appropriate here. Go ahead.
No, just I think that, like, I think we have to be very careful when we're talking about community safety and when we're talking about risk, because I think that those words have often been used to sort of hide the racist undertones of the criminal legal system, right? And that, oh, if we're just focusing on risk and recidivism, then, you know, it's a more just system, or it's a more fair system, or it's a more appropriate system. And I think we have to be very careful about that language. And, you know, it's so interesting because in New York State, and obviously in many other states, the fight for bail reform is ongoing, right? And this question of whether or not judges are allowed to consider, quote unquote, a person's risk in bail assessment is actually a huge point of contention. And obviously advocates for bail reform have argued heavily that risk should not be a part of the calculation at all. And so here we are on the back end of incarceration, basically making this argument that risk should be the sole factor, one of, you know, very few factors that we rely on to release people. So I think that there's a lot there and a lot to sort of talk about and explore. But yeah, I think that the statutes themselves need tremendous overhaul. I think that the appeals process, which basically involves, you know, appealing parole decisions to the exact same commissioners who denied parole, and then, you know, the remedy for a successful appeal, I should say, is just a new interview, potentially in front of the same commissioners, right? It's not as if it's, you know, an immediate grant of release or something like that. So anyways, I'll sort of stop there, but I have a lot of feelings about the statute and think that it needs a lot of work.
All of that is great and very helpful. And I think, you know, an interesting counterpoint, and I dropped this in the chat, but if folks are eager to think more about presumptive parole and to what extent it can be a transformative process or not, we've got folks coming from the New Jersey Public Defender's Office on April 12th who are going to talk to us about New Jersey's parole statute, which has had presumptive parole since 1979, and the unexpected counterintuitive result that the culture of the parole board kind of boomeranged in response to that big shift in statutory policy, and they ended up granting fewer and fewer releases of lifers in particular, right? So I think to some extent, you're absolutely right, Michelle, that there are big, important statutory changes that can be made. And then also we have to think about, and I think this is where we're leading the conversation here, because I know we're getting questions in the chat about community organizing. How do you then shift the culture around parole, right? Because part of this is still, if the decision is a discretionary decision made by the parole board, and if people people still don't have the resources to be able to adequately prepare. And if the boards aren't publishing data or giving people access to their records, and there's no coordination between the state prison system and the parole board in terms of thinking about which programs are actually available to people in the institution where they are caged, right? Can they be required to do something if they cannot access that program? And how is that fair in terms of enabling them to access parole, right? There are a whole range of things that may or may not enable one of those individual reforms to take hold in a way that will sprout. So I think it would be wonderful to hear about additional kind of organizing projects you all are working on. And I think fair and timely parole has been in the pipeline for 5 years, and I know people are engaged, and there's a big fight for elder parole in New York State as well. And I know Massachusetts is jumping on that bandwagon here. So I don't know if one of you, Anthony or Lisa, wants to talk about some of those initiatives.
Well, I can just talk about some of the things that we've been involved with. We have an opening on the parole board currently. And so that's one of the areas that we wanted to focus on, the transparency around that issue, because it's quite an opaque process. So we're going to basically try and shine a light again on why there's no criteria or public posting for parole positions, and it's pretty much left up to the governor to make a nomination for that. And then the governor's council confirms it. So that's something that we will be focusing on shortly. And we've, just in terms of some of the things that we've been involved with in terms of advocating, we've done a lot of testifying in terms of supporting or opposing nominations for the parole board in front of the governor's council, which has the role of confirming the governor's nominations. So we've been able to marshal a lot of our evidence that we gathered in terms of inappropriate commentary and absences and stuff like that to use against the nominations. And I have to think we've been somewhat successful in that, sometimes more than other times, but it just allowed us to get a lot more publicity around this stuff. And I think it really made a difference in the effect on the parole board. So I have to say that in the last, I don't know, 6 months, I mean, there's been a lot of changes in the parole board in the last 6 months. When Governor Baker was leaving, there was a bunch of changes that were made. And there's a new parole chair, Gina Hurley, who is quite progressive, and we're, I have to say, cautiously optimistic about what's happening in Massachusetts. So one of the things that I wanted to say, just for example, like the decision, the time for decisions, it was typically taking up to a year to get a decision. And now, they pretty much committed to under 90 days, which is really fantastic. We also are engaged in a dialogue with the parole board. So Patty Guerin, I don't know if you're familiar with her, but she's an expert on parole in Massachusetts, and she's a professor at Northeastern, and she is on our parole watch and has been a mentor to us, and she has been in a dialogue with the parole board. So that is really, really very encouraging. They've started to address technical violations. There's a calendar for commutations and pardons. There's actual bios of the board members on the website. And termination of parole, which is basic, for lifers who are on parole for the rest of their lives, this has really been a problem to get termination of parole. And so this is going to be looked at now, and there's new regulations, and they're committing to a 120-day process, a clear process, so with written standards. And the parole rate we've documented has really ticked up in the last few years. So starting in currently it's around 55% positive in the last 6 months or so, whereas we were started in 2018 with a 29% positive parole rate. So we're very encouraged by that.
Thanks for that. Anthony, do you want to tell us a little bit about some of the other organizing work around transformational approaches and coalition building, and kind of how people could get involved with that, build models similar to the work that you all have led in New York?
Right. I think that each state knows its own audience and the politicians, and that we have not created a template that probably fixes every other parole system throughout the country. We do know some of the basics that are involved. And it seemed like one of the things that I heard on here today was that individuals are able to appear in person before the parole board. And I think that's where Michelle was heading at the beginning, how it's a humanizing approach. What's wrong with this whole system? It's all a humanizing approach that we must take. In New York, individuals appear before the parole board on a TV set. And that itself is frightening, because we are living inside without a TV, most of us, and talking to a TV. Technology is something that we haven't got used to. And you can only see one parole officer at many times. And if you do see a second or a third one, they're reading something else. So it's very impersonal. It's very dehumanizing when you cannot stand before other human beings. I mean, I'm just saying, from the very model that we have in New York, I think is wrong. And that has not always been the case, but that is how it is now. We have got to the point where we are questioning whether we are even treated as human beings anymore. And I think the Attica Manifesto had, I think it's the second page on the Attica Manifesto, has said that we are humans and not animals. And so that's something that whenever you see something go wrong in prison, that is the issue on whether we're even human beings to be treated as human beings. We're usually demonized as felons, a French word which means evil, as if that has to do with our DNA, as if we're already, geared this way. I really do think it's wrong as a person of color to hear white people tell me about redemption, and that we cannot change and because of a violent, horrific crime, when the history of white people in this country shows us that white people have been some of the most violent people towards marginalized people inside of the history of the world. And so they do not stand on a moral hill to be able to dictate to other people what is right and what is wrong. I think that should come from marginalized people. In fact, most marginalized people do believe in redemption and forgiveness. And it seems to me that we're learning now inside the political spaces that I'm looking at, that this is not a matter of policy or what party you belong to. It's more who's in power when you want to use things as a red herring to continue to punish people. And that's not really the real issue. The real issue is economics, and it's racial economics that's driving this. And everything else is a red herring. Whether you use the crime or whatever, that depends on who does the crime that is used, but it's really race. And I think if this was another ethnic group, we would not even be having this conversation. It would have been over long ago.
Really appreciate those comments, Anthony. Thank you for that. We're getting some questions in the chat now, and we try to allow people to ask their own questions. So I would love to start with Lynn Sullivan. Lynn, do you want to ask your question?
Yeah, hi, technology. Gotta love it. All right, this has been an amazing topic. I did not plan on this one, so thank you very much, everyone, for sharing. So I am a lifer myself. So I understand that parole system. I understand that parole board. I understand that people are not prepared. Absolutely not prepared one bit when they walk in front of that board. I was one of those few ones that I don't know if you've ever heard of it, but I was actually appointed an attorney by the parole board in Massachusetts. Never heard it in my life, but it happened. Maybe all those letters I wrote, who knows, but I was very determined to get some kind of help from somewhere, and I wasn't getting it from anywhere, so I wrote and complained to everybody I could possibly think of, but it worked. But my thing is, what about a cap? We keep talking about bringing more people out onto supervision all the time, increasing it. When do we start taking people off it? You have people that are sitting in nursing homes that have offices going to a nursing home. Oh, you're good. Okay, let's go. Really? I could think of better ways of using our funding. You have people that have showed themselves for 20, 10, 20, 50, 30 years that have been on parole. When is enough enough? When are you taking up the time from our workers that are actually would like to spend time with those people that are coming out? Why are we wasting time sending them to people that have proven themselves in many ways, shapes, and forms for that many years, when you could be using that funding to help the people that are coming home, helping our parole officers have the staff they need and the material, everything that they need to make it more accessible for them to actually help the people coming home? When do we start putting a cap on how long we keep a person in supervision where they're constantly looking over their back, or they're worried about somebody that they don't even know that could sabotage them or put them in these risks and situations where people don't even look at and most will never understand?
Thank you.
But
Thank you for that
that's me.
question
That's my
and
question.
comment.
When do we
Yeah, it's a great question. In some ways, I know it's a rhetorical question for this audience because, this audience, I imagine, would say, how about tomorrow? But I think it's worth us talking a little bit about, and some background for your question that people may not know all in the audience is that in Massachusetts, lifers who get out on parole then are subjected to lifetime parole, right? So the presumption is that people will, and this is true in many other states as well, but the presumption is that people will spend the rest of their entire lives on parole. And again, I think Elisa alluded to the fact that there have been recent efforts, in part in response to a lawsuit filed by a class action lawsuit filed by a number of people on lifetime parole to be removed from it, and to say that the parole board, once again, back to our theme of due process, has not been providing any kind of material review of credible cases that say, look, this is not serving any purpose for any one of us. In fact, it's a waste of resources, like you're saying, Lynn. And the parole board went through a notice and comment procedure of issuing new regulations in response to that. Although I've heard from formerly incarcerated people, including longtime jailhouse lawyer Harold Adams, who runs the organization Inside the Sun, that in fact the parole board's new regulations conflict with statute and may even make it so that the period of time for which somebody has to complete parole is much longer now under the regulation before they can seek termination than the statute says. So I know that there are concerns about those regulations and whether they're going to be a boon for people to be able to seek release or actually a new kind of hindrance. And again, thinking about that constant in reform, right, of when you create something new, the way that it can be kind of used as a bludgeon or a cudgel to prevent release, even though it was nominally created to create opportunities for release, right? I don't know, Anthony, Michelle, or Lisa, if you all want to respond as well. And I know Almo's got a hand up with a similar question.
I did want to deal with the topic that was raised in part when I heard, well, that money could be used to other resources that's helping individuals come home from prison. The irony is around 15 years ago, there was a 80 billion budget for the prison industrial complex in the United States. $80 billion. New York State and California and Florida and Texas, they led in taking a big chunk of that. Homeland Security occurred, and a lot of that money had to be rerouted. Hence, a reentry incentive package was created by the federal government to say now downsize. And I want to bring this into focus to New York. New York has closed a dozen prisons in the last 15 years. In the last 10 years, it has sliced over half of its prison population down from 61,000 to roughly $30,000 people in New York State prison today.
Wow.
However, the prison budget is still $3 billion. They are managing away, despite the justification on them trying to knock down everything that's progressive as a way to keep it that way. Behind closed doors, they are managing a way to reallocate that fund. We're in a crunch right now in our budget in New York State. And the governor 2 weeks ago proposed to the Senate that the hiring age for correctional officers be lowered from 21 to 19, which then allows people from upstate district again to use the prison for a job program and keep the budget at all means high. These are people that are surviving based at other people's demise, at other people's expense. And again, if this was changed with another ethnic group, this would not be happening. So we rationalize our bills on how much money would be saved and how much could be reallocated back into housing and jobs and everything else. But now that we done did that pretty much with our bills, plethora of bills that we've been behind over the last 7 years, we still see the budget is the bottom line. It's the dollar. And as we follow the dollar, we see it's still going up into upstate communities. And I think that what's happening here may be happening in other states as well.
Almo, do you want to ask your question?
I do. Thank you so much. Let me lower my hand here. Okay, so my name is Almo Carter, and I work for the DC Public Defender Service. Our folks who have parole eligible sentences go into and serve their time in the Federal Bureau of Prisons and are under the jurisdiction of the United States Parole Commission. So a lot of this is a little different in terms of how our people are treated. But as it relates to lifers, I always tell clients and people, life does not mean life, because if you are released on parole after 5 consecutive years in the community of relatively good conduct, you may be terminated. And it happens. I've been at the Public Defender Service 24 years, and I've had several, I am very pleased to say, clients who had life sentences who were terminated. And all of the things that you all are saying about how the Parole Commission serves as a second judge and penalizing for the facts of the offense that are never going to change after 30, 40, 50 years of incarceration, it remains true. And I do believe that there are perhaps things that you all can do with your legislature. What our agency, and we're an anomaly because we are a district, a colony, but anyway, that is still somewhat controlled by the federal government. What happened very recently towards the middle to the end of last year is our special litigation. Now, we're the local public defender for the District of Columbia. We're not the Federal Public Defender Service. And our special litigation group basically made a settlement with the U.S. Parole Commission as it relates to early termination, because there's a lot of guys that just fall off the map. In addition to that, it could be a situation where they've been doing well for 4 years, and then the 5th year they get violated or whatever. And so we've reached a point where they've really tried to go back and identify, between our special litigation and the U.S. Parole Commission, identifying those individuals who have been out in the community on parole at least 5 years, oftentimes it's more, and have scheduled a slew of hearings. And so it's, again, something that has been, and they are entitled to attorney representation. So we do represent them in those early termination hearings. All they have to do is say, yes, I want PDS to represent me. And it works out that way. But in addition to that, we also now have supervised release, because our parole eligible sentences terminated August the 5th, 2000. So any offense committed after August 5th, 2000 is supervised release. So it's not indeterminate, it is determinate, with a period of incarceration followed by a term of supervised release. Even supervised release can be terminated early. There are some people, and it unfortunately tends to be sex offenders, who get lifetime supervised release. What? But again, you can petition the Parole Commission. I mean, and again, I've done it. I've written letters. It's like an appeal, if you will, appealing to the Parole Commission to terminate this person's supervised release for, very similar reasons, because they're doing well, blah, 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 blah. And because it's supervised release, they're not entitled to a hearing. So the only way to get before the Parole Commission is to submit a filing. But again, I say this because I can't imagine there not being groups in the states that can appeal to the legislature to change the law about these life sentences, because they are crazy. First of all, the fact that they're incarcerated for just crazy amounts of time, and then to expect them to continue to be on parole indefinitely, again, another just crazy thing. And again, as an example, it's the United States Parole Commission. Federal parole is different. So when they're looking to be terminated early or what have you, if they even are, I don't know about federal parole, they don't come to the Parole Commission, they go to the judge, the sentencing judge in U.S. District Court. But anyway, I just wanted to put that out there, because
No, it's a point well taken. And it's, I think, a good reminder that there's a lot of variation across various systems, right? And that even in states or jurisdictions that have a kind of progressive public image, right? New York and Massachusetts, we have represented here. Anthony gave us the figure about the % of prisoners in New York who are serving life sentences, and that New York is, the second in line, and Massachusetts is first, tied with Louisiana, right? And the carceral practices in Louisiana are very different than the carceral practices in Massachusetts. But when it comes to this question of long-term and life sentences, and then the back end of lifetime parole supervision that we have in Massachusetts, it's unexpected, I think, for folks, but important to bring out those nuances. And I think to tee up the question, perhaps our last question from Patricia that was asked early on in the chat, and Patricia messaged me to say she can't ask the question herself, but what are more community organizing initiatives around this? She asked specifically in Massachusetts, that must be where she is, but if there are ways that people can get involved in some of whether the legislative work or the direct kind of preparation and representation work, if you all can leave us on that note of positivity and action.
I can quickly just say that this isn't Massachusetts specific, but the Parole Preparation Project, which is based in New York State, is always looking for new volunteers to work with incarcerated people who are going up before the parole board. You can visit our website. I'll put it in the chat. I'll also just make a shameless plug for our upcoming Welcome Home Party, which is a really incredible celebration every year that we host to just welcome home all the people who were released from prison in the last year. And it's a really joyous, incredible time. We're going to have both an in-person event and a live stream. So even if you can't come in person, please, please, please consider buying tickets. The tickets are cheap. You know, you can get them for $25. Formerly incarcerated people are allowed to come for free and you know, bring as many loved ones as they want. And that's on May 11th. So end of my shameless plug, but please visit our website where you can see more information about volunteering. And then I'll also put the link to the People's Campaign for Parole Justice, which is the larger statewide movement that's working on the fair and timely parole and the elder parole bills that Anthony and I mentioned.
Phenomenal. Lisa?
Well, I just want to mention in Massachusetts, there's a bunch of legislation that's being proposed that, you know, on presumptive parole, medical parole, expanding the parole board, parole for elderly incarcerated folks as well. That just to mention that. Also, there's an organization called the Coalition for Effective Public Safety, which is an umbrella organization in Massachusetts that is also very focused on various advocacies that people are interested in. I think my email is in the chat if people are interested in that. And now I get to make my shameless plug for our project, which we are totally indebted to Michelle for. I mean, she's been just incredibly supportive of us. And we are called the Massachusetts Parole Preparation Partnership. We're led by Kim Jones, who is a parole attorney. We have a board currently with 3 lawyers, as well as Eugene Ivey, who is a life sentence on parole. We also have an advisory board in Norfolk Prison with 3 other incarcerated people. We filed with the state for our status, and we are close to a memorandum of understanding with the DOC, the Department of Correction, which will allow us to start a pilot project. We have 6 people who are incarcerated who are potential clients, and we have about 15 volunteers who are ready to jump in, and we've started training, and we hope to start in April. So I will put my contact in the email, but we're very excited about this project. And it was really Michelle's inspiration and the article that most of us read in the New Yorker, I think 4 years ago, about the New York Parole Preparation Project. So thank you, Michelle.
Thank you all so much. Anthony, I don't want to leave you out of any final comments. So I know we're already over time, but maybe you could take us out with any last words you want to add.
Right. So, no, thank you. I really cherish the opportunity to have been here today. Michelle and I would have been in Albany today, advancing our 2 bills probably. We are at the finish line almost with the majority vote on both of our bills. This is epic. We've been in this space for 10 years doing this work. In fact, this is our anniversary year. So please pay attention to the link and going there and join us. If you can't come in person, do join through the virtual world. And do know too that the work that we do, we're doing it to really save lives. And I think that resonates with everybody that's on here today. And I think one of the things that have happened that have really changed this space, and I want to encourage you all to be mindful, is because we do not receive donation from government entities, that we have donors such as yourself that make this possible, and that it is literally saving hundreds and thousands of lives. Our bills will actually affect around 9,000 people that's inside New York State Prison. And our work is being replicated right now in 15 other states. This needs to be done more, and I'm so thankful for the people that's involved with this work. So kudos to you guys. Thank you.
Thank you. Thanks everyone for staying an extra 5 minutes, and hope to see many of you again next week. And big applause if we were in a real space, you know, in person, we would all be, I think, cheering and hollering for you all right now. So feel free to send your emojis with the Zoom features, and thank you all so much for your time today. We really appreciate it.